Hello everyone, this is Advocate Vandana Swami and welcome back to my YouTube channel Law with Vandana. And do you ever heard about the term alternate dispute resolution or commonly known as ADR? So if you have ever heard about this and have you ever tried to go in depth about this that what exactly ADR is? So, from today onwards, we are starting our podcast series in which our very first esteemed guest is Mr. Anil Kumar Chaturvedi, who has approx 43 years of experience in the criminal laws, labor laws, corporate laws, electricity laws, banking laws, and insolvencies and allied laws. With International Arbitration Center, he is empaneled, and also with the Delhi Arbitration Center, High Court of Delhi. So we welcome you, sir. It's
Thank
a pleasure to have you on this podcast.
you. Yes.
So, sir, shall we begin?
Yes. Yes. Yes.
So, sir, we'll start with the very basic thing that ki what
Mm-hmm.
exactly alternate dispute resolution is. कि alternate dispute resolution होता क्या है? उसके बारे में if you enlighten us, it will be thank you.
Right. May I say little early years of our cultural heritage. So our history reflects that alternate dispute resolution mechanism was in earliest time was used by Ramayana Kal when Hanuman and in Angad were sent as an ambassador to make some compromise and to get solved and buy the peace. That was the first point. And second point in Mahabharata, when Lord Krishna went to Duryodhan, and in fact he went to Bhisham Pitama to get solved that at least you can offer 5 villages to the Pandavas so that war could be avoided. So these were two instances, and thereafter also many times when Rajputs were there and when Mughals were there, that time also these kind of things taken place. So, तो हम ये निश्चित रूप से कह सकते हैं कि अल्टरनेट डिस्प्यूट रेजोल्यूशन मैकेनिज्म हमारे लिए नया नहीं है। ये इसकी हमारी एंशियंट रूट्स हैं और ह्यूमन के नेचर में होता है कि बिफोर फाइटिंग विद ईच अदर some elderly people want this situation could be controlled by some resolution on some agreed common point where we can reach there. So in our post independence, our constitution also, when directive principles we will visit, we will find there that there is a in our main articles also equal protection of law, equity before law. So these kind of perception came from there. And when in 1980s it was realized that our litigation system is not working in the interest of the person, those who needed justice. So there were law commissions were there. So initially we try to make reform in our criminal justice system by so 1969 if you will find Khosla committee was there and they recommended on that basis our code of criminal procedure was amended so that trial could be expedited. And there is also you will find in CRPC many sections were added or given chances to the party to have compromise settlement in criminal law also. You will find section old section 320 and 21 you will find details of there in CRPC. Even in new CRPC, it is given recognition. So, like minor fight, minor this kind of dispute or offenses, if theft is below 250 rupees or lesser, those kind of things can be settled outside court. Simple injury, like so. There were two concepts: right in rem, right in persona. But so our law has recognizes right in persona where person can settle. But if offense is against society, those kind of offenses are not given uh, chances to compromise. So that is one part. Second thing, after this 1980s, it was realized that our legal system was overburdened with many of the because in trial court, in high court, pendency was increasing, and that had given chance to the again legislature to think about it. Then committee was set up, and if we see our one enactment came, Legal Services Authorities Act 1987. That is the first basis where Lok Adalat was conceptualized. It was added to our legal system that if both party agrees, then things can be settled before Lok Adalat, and those orders are not appealable. This was the first kind of things happened in our legal system after 1987. Then when I was in the electricity board as an advisor, chief law officer I was there. So said that time what happened, one case happened, and mainly cases were related to billing dispute. And before this Honorable High Court, one case titled Abdul Hassan versus DVB. It was converted into a writ by the Honorable Justice, those who later on became Chief Justice of Rajasthan High Court, Mr. Justice Anil Dev Singh. He is the person who has uh, brought into the system permanent Lok Adalat concept. What happened? I proposed it on the basis of one article written by Dr. A.S. Anand, who was that time the then Nalsa chief patron. Patron was Chief Justice and he was the head of that. So he wrote one article. What was that article? If we conceptualize permanent Lok Adalat in our system, then we can refer those cases if where even one party agree to go for Lok Adalat. This was the difference. But it was his article. It was not codified law. I borrowed his idea and proposed it before the High Court of Delhi. Fortunately, High Court agreed and passed the final order, which was reported in AIR 1999, Dell page 1999. This is the first case. So, by virtue of it, we as a PSU established two permanent Lok Adalat. We begin with the near Mata Sundari College in Delhi. We ourselves developed the infrastructure, and Honorable High Court nominated the judges. And first judge in permanent Lok Adalat was occupied by the then Justice Satpal, who retired from Punjab Haryana High Court, and another Justice S.N. Agarwal, who retired from our district judiciary in Delhi. And you will not believe that 50,000 cases were referred. 50,000. And within a period of 6 months or so, we were able to resolve around 45,000 cases. We brought down pendency from 50,000 to 45,000. This was the achievement, and we recovered 975 crore audit as a revenue for DVB, which was locked up in litigation. And suppose we would have followed the litigation route, it would have taken decades to recover that amount. And God knows what would be outcome of those cases. So this was the in short I want to tell here. Then when I was in the Ministry of Corporate Affairs, our new enactment was in the channel. So I was also part of one of the team as a member. So I proposed the idea before, and my secretary he then agreed also, which was ultimately enacted by Parliament. And 442 section is there, mediation in corporate law. It was unheard earlier. So now suppose corporate try to refer matter to mediation, it can be possible. And our ministry impanel the mediator also, because we were
Sorry to
talking.
interrupt you in between,
Uh,
but will you please explain about mediation? What is
yes, yes,
mediation exactly for
certainly. I am
all?
coming to that. I was just giving background so that when we talk, we should know the terms. So now come to the this main topic of alternate dispute resolution, ADR. As we know, in our today date, even last data which was published by Law Commission or somewhere, 5 crore 50 lakh cases are pending in our legal system. And as an advocate, you can also realize, I have already realized that what is the disposal rate in before various judicial forums. Litigants are waiting for decades. So in 96, our the then law minister proposes Arbitration and Conciliation Act 1996 based upon Unique Trial model. So when it was introduced, so that act has three kind of procedures. One is arbitration, second is mediation, and third is conciliation. There are three modes of alternate dispute resolution as of today. And now after this 2016 amendment, our system has realized that institution-based arbitration or institution-based mediation is the most viable idea. And thereafter, you can see that even in Delhi International Arbitration Center is established. In Andhra, you will find in every high court now they have established arbitration center where matters are referred, and every high court has also followed the system of mediation, and they have started giving training to young lawyers, those who have some experience as a trained mediator, because mediation is not a very simple thing. What is the difference between arbitration and mediation? In arbitration, except this regular court where sole arbitrators are there or odd numbers of arbitrators are there, like 3, 5, 7, 9, like that. Mostly three are there, and one are sole is also there for minor matter. So once appointed, so here what is the condition? The party has to make request based upon commercial agreement in the contract where arbitration clause is proposes. And what is added there? You will find word is used negotiation. That gives light to the mediation. Means it is not necessary every matter should go for arbitration. The first remedy is mediation is also there. Every commercial agreement start in the beginning, not at the end. You will find all these things. Depending upon what quantum of dispute, what is the nature of dispute. So that is one way. In arbitration, what is the benefit you have? That it is protected by law. In our law, no appeal lies against arbitration award except section 34. That is called, talks about clerical arithmetical error or some basis where arbitrator is biased or he has joined some one of the party, then arbitration award are cancelable. And where appeal goes against the award in Delhi up to 1 crore 1999 lakh, district judge is the forum. And beyond that, High Court, original side. This is the one thing. Third thing is there, suppose agreement is not there, then what? Then Section 11 of Arbitration Conciliation Act gives liberty to party to go to the High Court and Supreme Court and they can get appointed arbitrator. This is the procedure for arbitration and arbitrator appointment. If you want, I can explain you how arbitration are initiated. Then I will come to mediation and conciliation. That will be okay?
Definitely, sir.
हाँ.
That will be fine, sir. Completely.
Yes, 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 yes. So, like whether a person is sole arbitrator or it is institution based, where 3, 5, 7 numbers are there. What is the difference between institution based and this? They are based upon commercial agreement. Each party is given right to appoint one arbitrator from his side, and those two arbitrators nominate third one, which is the neutral one. This is one way. And suppose both parties don't nominate third one, then what will happen? Institution says if it is through institution will nominate one arbitrator from his panel maintained by. This is one way. International commercial this agreement, then Singapore, Malaysia, UK, and now in India also, we have India International Arbitration Center, where person can approach for international, where two countries or more are involved in contract. That is called international award arbitration. Sorry. So, what after appointment of arbitrator, what happened? Like if it is institution based like DIAC, they will write to arbitrator, you have been nominated or proposed to nominated as arbitrator, furnish your neutrality declaration. Then as per section 12 of the act, we have to file a format is there. We declare that we are not related to either of the parties, nor we are connected in any past this commercial activities or any other interest with the affected party. Like there are two parties, so we don't know none of them. That declaration is must. Before earlier, what was the system? People were doing. Then after that, biased arbitrator is there. These kind of allegations were coming. Now after filing of this your declaration, what is to be done? Then party has right the neutrality of the arbitrator within 30 days before the High Court or before the forum that he is the biased man. I don't want this arbitrator. But he has to give evidence. Then court decide. Not DIAC will not decide. Court will decide, like High Court or High Court normally decide in them. So this is one of the way. Then after appointment and declaration, arbitrator asks to the parties to file a statement of claim. First claimant will file what is his claim against the respondent. Then respondent file a statement of defense, SOD. This is called SOD. First is called SOC, statement of claim in short, and second is SOD, statement of defense. After receiving the statement of defense, claimant can file rejoinder to the reply. This is the one process, just like CPC. It is just like CPC. So once pleadings are completed, then parties are directed to appear before arbitrator. That is first hearing before arbitrator. Before that, no physical hearing. And then before arbitrator, they are asked to furnish admission denial based upon the pleadings. Each party has right to give admission denial so that dispute could be restricted or identify what is the dispute. Thereafter, they file issues. Just like in civil court, each party give his issues before the arbitrator. And it is the discretion of the arbitrator based upon admission denial. He will finalize final issues. And after issues are framed, then each party is directed to file affidavit by way of evidence. That is called evidence. So each party has his own deponent, and once they file the affidavit by way of evidence, so on the date fixed, other side cross-examine the witness. Their examination chief is not taken place, mind it. There is by way of affidavit. So he will tender the affidavit, then other side will be asked to do the cross-examination of the witness. Suppose witness is cross-examined and claimant side feel like that he has to re-examine the witness. He can do that also. So same way, statement of defense after filing, claimant has right to like a claim. Statement of defense side has right to file counterclaim also. So same process will follow again counterclaim also, like statement of defense and rejoinder, then issues, and then like that. So this is the process of arbitration. So after evidences are completed, then arbitrator write his award, and that award is published in presence of the parties. If parties are not coming, he will publish, and he will send the copy of award to each party. Party, when I say the affected party, not advocate. Advocate cannot collect award. They can get copy, but main copy will be given to the person who has to implement the award. Otherwise, recently you have seen in Supreme Court, one case is decided. They have given to some proxy. So that was not treated as proper service of award. And but other side in the case anyway. So this is the process of arbitration. Now, please.
Here's one question from my side is that arbitration, very oftenly we heard that
Hmm.
arbitration and mediation are key ADR mechanism in India.
Hmm.
So up to what extent you agree with this, sir?
See, if you see our legal enactment, mean this from where we are drawing the power. Mediation. What is the difference between arbitrator and mediation? Major difference is mediator is a facilitator. He can't decide, and he can't share information outside world also. When both parties appear for this mediation, so each party come with some point, common point, where they can arrive at some. That is called process of negotiation. Before mediation is negotiation, and once they agreed, then it is drawn up by the. What is the role of mediator? Just to draw the mediation award, you can say, or award, you can say. Award is the fine word. So once this mediator finalize the award, it given to the parties for implementation. But what is the drawback in mediation is either of the side they feel like they are not getting anything, they back out also, and there is then whole process is started with the again litigation. So this is the one of the things we should keep in our mind. Mediator award is not final. It can be revert. Reversible means when either side can back out. Yeah, I don't accept this award. he can blame anything on mediator also. So that's why when award mediation fails, mediator never inform outside world. He just give report in sealed envelope. As a mediator, if you are acting, you have to give to the concerned judge or forum which has nominated you as a mediator. That report is given in sealed cover. Neither of the side is not aware till it is submitted to the court. What is the award mediator has said, because mediator cannot disclose and he cannot share outside world his information and knowledge driven from the east side. In many family matter, mediation takes place, but we can't share what husband has said inside, what wife has said. If you have seen the process in mediation, always one party go out when the mediator talks in camera to the one party, either alternately, and then he framed his idea whether can mediation reach or not. So I hope I'm clear or not. Huh?
Yes,
Huh?
sir, very clear. Actually, I have witnessed.
I am not very fast. I am
No,
not
no,
fast. No?
no. Completely fine, sir.
Uh,
Sir, India is a growing economy and
yes.
requires efficient dispute resolution mechanism. In this context, what is your point of view about the role of arbitration and mediation in achieving timely justice and attracting foreign investments in India?
Yes. Yes. So in what I have realized is, though of course it is quite late, when Arbitration Act was enacted in '96, and now we are in 2025, and we have hardly within last 2 3 years started process of institution based arbitration. Earlier, what was the system? Arbitrators were nominated by the court. Now there is a panel also. Earlier there was no such kind of panels. It was the mercy before the judge who nominate the arbitrator. And of course, normally they were preferring retired judges because they have vast judicial experience. So they court has confidence in those judges. And advocates, if you want to become arbitrator, minimum experience required is 10 years. Or even 10 years is no guarantee. That is the drawback. To my understanding, they should reduce it to like advocate on record has 4 years nowadays experience for
Yes.
advocate on record. Same way here also for a small arbitration matter or mediation matter, they should reduce it to 4 to 5 years so that ample number of arbitrators and people are there to take over. And it should be uh, mandate of the law that before going to civil court or commercial court in any matter, first person has to go to the either for arbitration or mediation. Then we can reduce the number of pendency. As I give an example of Lok Adalat.
Yes, sir.
That time there was no permanent Lok Adalat. I was called by late our law minister. He called me. He said, "How you could have got this order from High Court without having legal provision? Normally, High Court gives order based upon some provision in law, but on writ side, honorable judges has ample power, and that had become. If you will see the Legal Services Authorities Act, you will find amendment was added later on 2004 or so. You will find some A section is added, permanent Lok Adalat. Before that, there was no section. And we have introduced in 70 departments of Government of India because Delhi High Court deals with the Delhi only. So concept of permanent Lok Adalat was made permanent. And still it is going on now. You can see in Delhi, other places also you will find this concept permanent Lok Adalat. So we can always reduce the pendency. To my understanding, we can always reduce dependency.
So it was a very insightful and knowledgeable session and podcast with you.
Acha, another one more thing I will add it, conciliation.
Yes,
We
sir.
have forgotten to that touch that point. But conciliation, there is a conciliatory authority concept, and those conciliator assess the dispute and discuss with the parties, and they frame their opinion and they give the award there also. But that don't have any force of law. And either side can back out like mediation, because conciliation means both sides should agree. In our electricity board, conciliatory authorities was formed in 99. I am telling you. So then this permanent lok adalat came. So I was on receiving hand from those judges, because this was the authority of the conciliator. They say how you can do that. I have not uh, uh, dissolved those conciliatory authority. What I did, all pendency I got it transferred to permanent lok adalat.
Sir, what are the advantages and disadvantages of ADR? If you can put a light on this, it would be a great to know about
See,
this.
in ADR, person need not to be depend upon advocate only. First thing, party has first-hand approach to meet the arbitrator, mediator, or conciliator. He can express his matter. While in formal court system, he is dependent upon lawyer, because he has to first drafting, then notarization or affidavit, then filing. So many complications are there. Here there is no such complication. He can he can hand over his claim to the arbitrator by hand. Arbitrator can share the copy of claim to the respondent side in his presence. There is no need of registry. There is no registry in our this arbitration. Arbitrator himself is the judge, himself is the registry. So, acha, there is no stamping, except notarization is required because of law of affidavit. So that he is saving cost. Third thing, he need not to be dependent upon advocate. If he can plead himself, he can plead. And young lawyer will have more chances, because in litigation, small matters, suppose. So what is the benefit for young lawyer? At least those matters where party is unable to engage a big advocate or firm, so they can go to that arbitrator or mediator. Let wise resolve this dispute. So it is a cost saving, time saving, and plus award is final.
And sir, what
And
would
I
you?
do not know whether in our education system it has been made compulsory, Arbitration Conciliation Act.
Yes, sir.
Those persons should be given adequate training also
सर क्या
through institution. Yeah.
आर्बिट्रेशन के बीच में पार्टीज कोर्ट जा
Uh,
सकती है if at any point of time they wanted to opt for the litigation whether
no, once matter is referred for arbitration,
yes
unless until they are able to prove arbitrator is biased, I said so, or arbitrator is taking more than 12 months time, because here time limit is 12 months. After admission denial, once evidence is filed, it takes normally 4 to 6 months, because of our legal system here. Otherwise, it can be done in 1 month also. Advocate takes time. Give me 4 weeks time, 6 weeks time to file defense. That is a drawback. And after 12 months, award is final. You are getting justice within 12 months. What else you needed? Why party will go to court of law? There, even in High Court nowadays, I have seen 3 4 months dates are given, common date. If you are appearing in some matter, you don't get date of like 3 days or 4 days after. No, they will give you date at least 4 months, 5 months, many times 8 to 10 months also, depending upon pendency in the court. Huge pendency is lying everywhere. So my alternate dispute resolution system, it should be made effectively, and parties should be also educated by, like law schools are there. You are part of one of the law. I propose to many professors, you organize camps in the villages. Tell them, what was our panchayat system, sarpanch system. If you remember, Panch Parmeshwar, one story was there in our, when I read in academics. Resolution only. Actually, what system is given to us by Britishers, it is a colonial system of law. Like, if they want to reduce the pendency, in my view, this appeal system should go. Why you suspect one judge? You have seen quite difference between judgments of trial court, appeal court, or second appeal many times. So you are giving so much discretion to the judges. That is things to be seen by our law. If law is defective, then law should be rectified. Many times our says that legal reform should take place in this country, which is the most, I think, demanding. And young people are, I have seen in my time, hardly one or two girls were part of our law system. I am telling you. Nowadays, it has attracted many young people are coming with lot of aspiration. So, from where they will get the work? Alternate dispute resolution. This is the only way out. Law is not cure for all things. Law should be made for serious offences or big matters. If you have seen in US and other places, within 3 months you get the justice is given. Why in this country can't be done? It can be done. So
Thank you so much, and it was a very insightful session with you.
thank
And
you.
surely, I'm
Okay.
hoping that we'll have you again on our
Sure,
podcast,
sure, sure,
and
sure.
we'll discuss more things about alternate dispute resolution.
Yes, yes, yes.
Because
Why?
in one podcast, I truly believe that it's impossible to cover every aspect.
Yes, yes, yes.
And thank you so much, sir, for coming over today. And it was a very great
Okay.
having you here. Thank you
So
so much. Thank you for being here. Thank you so much, sir.
I am happy to see you. You have so much interest in you. You have initiated. It's a great achievement for you. For in my eye, in my time, we were not even given think even what should be done. At least you have uh, given thought to social problem, huge pendency of cases. Who will do all this judgment? I still remember one of the case where Supreme Court has given verdict. You know how much time it has taken? 45 years. 45 years. The claimant original gone to heaven. And what was the dispute? Roadside